Got a question for you. Can you have copyright infringement if there's no copying? It would seem to be in the name, wouldn't it? You have to actually copy something in order for there to be copyright infringement, to infringe on someone's right to copy. Yes, we're talking about another of the AI cases, and this is one where class members split off from Bartz v. Anthropic. They opted out and said that we're going to file our own lawsuit. This is the lawsuit from a few of them. And they probably should have stuck with the settlement, because it seems kind of like they want to start over and they're not going to be able to start over. So here we have Anthropic's motion to dismiss, where they talk about the problems with it. They say plaintiffs are authors who claim Anthropic infringed on their copyrights by using their books to train LLMs. They have not alleged, nor can they, that any Claude model's output reproduces their books. Rather, they claim that Anthropic's LLM training process itself infringed their copyrights. So they're not giving any copies of books to anyone else. So they opted out of Bartz v. Anthropic. If they had stayed in, they could have gotten $3,000 per book. Just stay in there and get the money. But that wasn't enough for them. Instead, they want the maximum statutory award of $150,000 per work, plus attorney's fees and costs. But originally, they brought only a claim for direct infringement. This second amended complaint adds two new theories. So it's a second amended. There was the original complaint, then they amended it. Now they've amended it for a second time. So they're taking 3 bites at the apple here, trying to get it right, and they still can't. So they've added contributory infringement and removal of CMI. All 3 counts fail. Regular viewers, you can guess where a lot of this is going with it, but of course there are the usual twists, which is why I'm covering it. So stick around. Their theory is that Anthropic, while torrenting books to train its models, uploaded pieces of their works to other users who then infringed. So remember, we've talked about how BitTorrent works, how as you're downloading, the parts you've already downloaded, you can go ahead and cede to others. We talked about that in Cadre v. Meta, and we talked about all the steps Meta took to make sure that didn't happen, and they're suing for them anyway. I think it's the only count left in Cadre. We don't know what Anthropic did as far as preventing seeding is concerned, because none of these cases have gotten that far yet. But that's what they're saying. But they identify no direct infringer who ever received any piece of any of their works from Anthropic. They can't actually show it happening. And it wouldn't even need to be anything they could say, oh, it's this IP address. They wouldn't have to say it's like, George in Leeds or whoever. Or even just this sort of discovery would let us know who it is. They haven't even done that. They claim only that torrenting protocols are often configured by default to re-upload data. Nor does the SAC suggest that Anthropic intended that the provided service be used for infringement, as the law requires, again, under Cox. Cox is really knocking out a lot of these at the knees. Then the CMI removal, we've gone over that before. That fails for 3 reasons. First, the only removal alleged would have taken place within Anthropic's internal training pipeline, and plaintiffs allege no CMI stripped copy of their works reached anyone. Second, they do not plausibly allege that Anthropic removed any CMI at all. They allege CMI was already stripped from works in the dataset Anthropic acquired. And third, they plead neither of the 2 scienter elements that we've gone over before with that. Plaintiffs not only failed to state a claim under the statute, they allege no dissemination of any CMI stripped copy, and so failed to allege even a cognizable Article 3 injury. Again, no copy, no infringement. And also, Your Honor, there's a 3-year statute of limitations. Every act the SAC challenges is dated 2021 or 2022, and plaintiffs didn't file until December 22nd, 2025. They waited too long, Your Honor. Also, 2 of these guys, Cochin and Beretta, each sue on copyrights that public records show belong to other parties. It's not even their works, Your Honor. The copyright isn't even theirs. But only the legal or beneficial owner of an exclusive right may sue for its infringement. Actually, there is a case where a judge up in the SDNY said otherwise, like, not You can sue for infringement of someone else's copyright. Yeah, you can do that. Yeah. Maybe I'll do that one next. Hopefully that one doesn't go much further, but I'll cover it. So Cochin's An Independent Empire wasn't even registered until July 2023, years after the alleged copying. So unless Anthropic has a time machine where they can go back and do the training on the registered copy, then you can't do it. Because the copyright didn't exist yet. And not only that, Your Honor, plaintiffs again assert a non-exhaustive list of unidentified copyrights, the kind of placeholder claim courts routinely dismiss. Alright, so let's look at the contributory infringement claim. The SAC speculates that by torrenting books for its own training, Anthropic must have uploaded pieces of plaintiffs' works to unidentified peers who might have then infringed. So in order to show infringement, they would have to show that when they downloaded them, they seeded the files, and those blocks were then uploaded to someone else who then was able to get a complete copy of the work and infringe with it. They have to show all of those things, and they don't even allege it. Plaintiffs plead no act of third-party infringement and no intent by Anthropic to facilitate infringement as required under Cox. To start, the SAC identifies no direct infringer who received any piece of any allegedly infringed work from Anthropic. This causes plaintiffs' claim to fail because the existence of direct infringement is a necessary element of a claim for contributory infringement. That goes back to Concord v. Anthropic. Nor is a general reference to how torrenting protocols are often configured sufficient to state the claim. Plaintiffs assert that Anthropic uploaded and distributed, either through seeding and or leeching, copyrighted materials, but the only fact they plead in support is that torrenting protocols generally are often configured by default to re-upload pieces of the copyrighted files. Plaintiffs' own allegations concede that the protocols are not always configured to enable seeding. The SAC pleads no IP address, no transaction, no log, and no recipient for any alleged infringed work. Whether Anthropic's client was configured to enable seeding, if so, whether pieces of those specific 7 works were among any uploaded, and whether any third party downloaded them are all left to speculation. And contributory liability also requires intent to bring about another party's infringement. They have to have meant for that other guy to get the copy and infringe with it. The Supreme Court recently explained, in Cox, that the required intent exists only if the party induced the infringement or the provided services tailored to that infringement. Mere knowledge that a service will be used to infringe is insufficient. The uploading, as alleged, will be dependent on how third-party software ships by default, not on any intentional act by Anthropic to encourage a third party to infringe. So the only thing Anthropic could possibly have done is turned off the seeding they're talking about, which would mean their intent is to go the other way. You see how this fails no matter what? If they just left it at the default, there's no intent. If they changed it, the intent was the other way. And if plaintiffs fault Anthropic for allegedly not disabling default settings, Cox foreclosed that theory too. A court would be unable to find contributory infringement liability merely based on a failure to take affirmative steps to prevent infringement. And likewise, if they weren't sufficient, like if they tried but a few slipped through anyway. And count 3 fails as well. Plaintiffs allege no Article 3 injury. They do not plausibly allege Anthropic removed CMI from any of their works. They plead neither of the 2 scienter elements. Each defect alone requires dismissal. Any alleged act of CMI removal by Anthropic happened inside Anthropic's internal training pipeline. They do not allege any model outputs that contain their works and lack CMI. And again, remember, we've got that other case where they didn't do that. Drawing a blank on the name of the case again. But it hallucinated the CMI and they said, oh, that's a trademark violation, and they sued them. So, no matter which way you do it, you're getting sued. You see how these people operate? Raw Story v. OpenAI was actually dismissed for this. They applied these principles to materially identical allegations. The court dismissed for lack of standing because there were no adverse effects from the removal itself, no output of their works lacking attribution, and no substantial risk of any. The same is true here. When CMI is removed from copies that never leave the defendant's servers, no reader encounters the work without its attribution, and every copy available to the public still bears the author's name. Plaintiffs' own allegations explain the need to remove CMI, and it has nothing to do with infringement. The tools were allegedly used to create high-quality LLM training data and to optimize its model's performance. CMI filtered out along with footers, boilerplate, and other noisy data, take out the page numbers and everything, in the course of preparing training data is not removal undertaken with knowledge that it will aid infringement. That's from Tremblay v. OpenAI. That gives us two districts saying that. Tremblay is from this very district here, the Northern District of California. The other's from the SDNY. And if it's not good enough for the corrupt SDNY, it's not going to make it. And we've also got Cadre. They rejected the same theory over there. Anthropic allegedly downloaded Books 3 in 2021, torrented LibGen in June 2021, and torrented Polemy in July 2022. And it selected and used the CMI removing extraction tools in 2021. Yet plaintiffs didn't file this case until December 22nd, 2025, more than 3 years after the most recent of these acts, even assuming the newly added contributory infringement and CMI counts relate back to that original filing. They waited too late, Your Honor. They got to do it in 3 years. The SAC vaguely suggests Anthropic attempted to conceal the composition of its training datasets. Plaintiffs allege no affirmative conduct, only a vague allegation that Anthropic attempted concealment without explaining what the attempt was or whether it succeeded. Nor do plaintiffs allege any facts to show they were diligent despite Anthropic's supposed attempted concealment. And check this out. Any notion of concealment is inconsistent with plaintiffs' own allegations that Anthropic described its training sources to the world in a December 2021 research paper. That's a funny way of concealing, isn't it? Published in the paper. The same paper to which plaintiffs' original complaint traced their entire theory against Anthropic. A defendant that publicly discloses the very facts said to be hidden has committed no affirmative act of concealment. These cases just get better and better, don't they? Every time it's something new to laugh at. Now, Beretta's and Cochin's ownership allegations are contradicted by their own registrations. They lack standing. The legal owners identified in the copyright registrations are necessary parties under Rule 19. Beretta and Cochin must either join them as parties or plead affirmatively why their joinder is not feasible. Because they did neither, all of their claims should be dismissed. And also, no statutory damages or attorney's fees are available for an independent empire, which wasn't even registered until July 2023. The SAC alleges the copying commenced in 2021 and 2022. Doesn't work, Your Honor. So the court should dismiss the CMI and contributory infringement counts in their entirety. The court should dismiss all counts as untimely. Get rid of them, Your Honor. Yes, they copied them by not copying them, and they concealed them by telling the world about them. Oh, we'll see what the judge says, but it doesn't sound good. I think the only thing they might be able to succeed on is the statute of limitations, because they say, well, we only did this when we decided to opt out of the Bartz settlement, but they've had 3 different complaints in which to allege that. They haven't yet, but we'll have to see what the judge says. This might not be over, but a lot of these most of this should probably be gone. Oh, we'll see what happens with this. Until then, thank you so very much for watching. Comments for the Comic God, shares for the Share Throne. Please hit like, subscribe, and the bell, and of course, donate. Doppagosity.tv keeps me doing this, whether with one-time donations or regular support. So thanks again, and until next time, stay strong and be free.